I want to say welcome, everybody. Thank you for coming today to the Hoover Institution. The Johnson Center is the Hoover Institution's outpost here in Washington, D.C. We are part of Stanford University, and thus we are in Washington, but not of Washington. But it's our pleasure to welcome you here today for the latest installment of a series we've inaugurated here called Opening Arguments, Conversations on American Constitutionalism. The idea is to discuss constitutionalism in its best, broadest senses, not just narrow legalisms, although I like that too, I'm a lawyer, but also to look at the deeper principles that undergird our Constitution, and also to discuss the way we govern ourselves today. So our last couple of speakers have included Professor Josh Blackman on the Affordable Care Act, and then the previous speaker was journalist Matt Continetti of the Washington Free Beacon to discuss populism and nationalism. The series is based on President Hoover's description of the mission of the Hoover Institution. In 1959, he wrote to the Board of Trustees, "This institution supports the Constitution of the United States, its Bill of Rights, and its method of representative government. Ours is a system where the federal government should undertake no governmental, social, or economic action, except where local government or the people cannot undertake it for themselves." Our upcoming speakers are May 5th, we'll have Rabbi Meir Soloveichik to discuss religion and the state, based on his recent article in First Things called King David. And then in June, on June 21st, we'll have Professor John Inazu on his book Confident Pluralism. And we'll be announcing other speakers as we go, so please, if you're not already on our mailing list, please do sign up. And we appreciate having you here today. Especially appreciate having our speaker, Professor Hadley Arkes. Our subject today is natural law and the Constitution. And on that subject, there is no one I would rather have with us here today than our speaker, Professor Hadley Arkes. Hadley's been teaching students at Amherst College since 1966. Is that a typo?
No, I was a little boy.
Where he's been the Edward Ney Professor of Jurisprudence. But for decades, he has educated generations of students beyond Amherst, and I'd like to count myself among them, through his public speeches and through books like Natural Rights and the Right to Choose, Constitutional Illusions and Anchoring Truths, and many others. His book on principles of morals and justice, titled First Things, inspired Father Richard John Newhouse to use the same title, and I'm pretty sure the same font.
Same font, yes.
For his famous magazine, First Things. I'm glad you picked a nice title. You could have picked something else, I suppose.
Well, I told Richard that my next book is going to be called Urology and What It Can Do for You. To see what kind of a journal he would make out of it.
In all of his work, Hadley challenges us to think more deeply about the principles that undergird our written Constitution, and always, I'd add, with an irrepressible smile on his face. See what I mean? Having taken emeritus status at Amherst, Hadley recently founded the James Wilson Center on Natural Rights and the American Founding here in Washington. It's my immense pleasure to welcome him to the Hoover Institution today. Hadley Arkes.
Thanks so much. Actually, and thanks to my friends for coming out. It struck me that this is one of those incidents. We have Ted Hurd here, we have Steve Adden, we have any number of these people could simply take my place if I'm floundering.
That's true. And so well, we'll see if it comes to that.
Okay, but first I want to say, if I can bail out, first, maybe it's because I'm getting older, like I feel kind of a paternal style. I don't want to embarrass Adam, but I really am so proud of him, of what he's accomplished.
Thank you.
He's made himself one of our really leading, along with Andy McCarthy. I mean, Andrew's made himself one of our leading writers on law, making these questions accessible to a wider audience beyond the circle of lawyers.
Well, now I'm really, really glad we invited you today. Thank you.
Anything else that has to be done? Okay.
All right, Hadley, let's start. You literally wrote the book on First Things, so let's begin with First Things. What is natural law, and what does it have to do with our Constitution?
Oh, a president at Amherst College once said Hadley has a theory of natural law. My friend Dan Robinson said, who's done 18 books, said he wanted as the epitaph on his tombstone, he died without a theory. And I say, when you say you have a theory of natural, you imply that some of us are standing back in a kind of wholesome detachment, watching theories was passed. And somehow we can make judgments about the fragments of those theories that are plausible or implausible, true or false. Now just take me back to the ground on which you make those judgments, and you will have arrived at the canons of the axioms of reason, and which some of us take to be the very ground of the natural law. And that's what that first generation of our jurists did. You know, Greg Katz's, when he was doing the first day in the argument over Obamacare, recalled that line of John Marshall's in the Dartmouth College case, saying that it could be as bad to impose upon people a contract they do not want as to impair the contract they had willingly made. And Justice Story will later say that principle would be true even if there were no Constitution. Just as John Quincy Adams would say, the right to petition the government is implicit in the very idea of a regime of law. That would be there even if it weren't in the First Amendment. It would be there even if there were no Constitution. Because what natural law involves really is taking things back to the ground on which that first generation really trace their judgments back to the deep axioms underlying their judgments. And I think that throwaway line by John Marshall at the end of Gibbons versus Ogden, where he apologizes to his readers for spending so much time demonstrating what should be the class of an axiom. He assumed that all of his literate readers knew that before you can carry out a demonstration, the ball rolling down the inclined plane, I have to know, here's this angle, that angle, I've got to know that A does not equal non-A, I've got to know the law of contradiction. If I don't know that, I can't get into the demonstration. I can't explain it to you in the form of the demonstration. You've got to know that before we enter the demonstration. And that the founders were utterly clear on this was nowhere illustrated with more economy and elegance. If you forgive me.
No, please.
That in that opening paragraph that Alexander Hamilton struck off for the Federalist 31 on taxation. And in the course of that paper, he reached no conclusion different, say, from what Bob Dole or Chuck Grassley would reach in their own time, but any disinterested observer looking at the text would notice at once some strikingly different furnishings of mind. Mm-hmm. This is how Hamilton said. He said, in disquisitions of every kind, there's certain primary truths or first principles upon which all subsequent reasonings must depend. These contain an internal evidence which, antecedent to all reflection or combination, command the assent of the mind. Of this nature are those maxims of geometry, the two lines cannot enclose a space, two things equal to a third are equal to one another, and of like nature are those maxims of ethics and politics, that there cannot be an effect without a cause, that the means must be proportioned to the end, and there ought to be no limitation placed on a power destined to effect a purpose which is itself incapable of limitation. Just the way Bob Dole would have said it, I think, if he bent his mind to it. To finish the story, I recall a scene several years back where Bob Bork and Dan Robinson were talking. He said, I'm closer to Robbie than I am to Hadley. What was it? Hadley thinks that the natural law bears on the cases before us. He said, I don't think you have that on. That's quite the point. First of all, your argument is, what is a case? A case makes sense only as an instance of a practical judgment to which you are applying a principle. In the very scheme of making legal decisions based on a series of first principles, some expressed in the Constitution, is itself a scheme of natural law. This is the way that first generation did it. I went on too long with the answer to the question.
The first generation being, you've already mentioned Marshall, Hamilton, James Wilson, for whom your institute is founded. Right. Any other representative examples you'd like to mention?
I think they're the best, but people are doing this all the time.
Yeah. Well, so if these principles precede the Constitution, they undergird the Constitution, why do we need a written Constitution at all? Why not a Constitution of just a couple of provisions, at least with respect to the Bill of Rights? Why not just have the Ninth Amendment and then be done with it?
Somebody asked me once, you don't really need the Constitution to. Yes, it matters profoundly to me as to who succeeds if a president dies in office, and when the presidential term begins. These are matters of structure. You can have the principles of natural law, but they could be consistent with a variety of structures. But this is what the founders understood. They didn't think remember when the question arose of putting in the text that principal and ex post facto laws, Oliver Ellsworth and James Wilson objected. They said, God, everybody knows that. Everyone knows that. You can embarrass us in the presence of the urbane in other countries. You put that in, nothing else. They'll think that that's these only first principles the American founders knew. Look, every so often people come to recognize that Kant was right, that we cast moral judgments on people only in the domain of freedom where they have the active powers to cause their own acts to happen. Mm-hmm. We understand that it makes no sense to hold people blameworthy or responsible for acts they were powerless to effect. Well, Wilson regarded that as the first practical judgment of legal judgment and moral judgment. That's not in the Constitution. Yet that principle forms the core of the insanity defense and many other things. Of course you can't put them all in, and the people who wrote that document didn't think that they should be putting them all in. Obviously there are things we didn't think of right now, and we don't need a damn Ninth Amendment in order to do that kind of thing.
Well, it's good we have it, though, right?
I'm not sure. What did Neil Gorsuch? It hasn't been interpreted. Oh, it hasn't been interpreted. So if I come out with that line, one of the deep principles is we don't hold people blameworthy or responsible for acts they were powerless to effect. You mean I need some judge to have articulated that before I can say, that is implicit in the scheme. It means that there are things there we hadn't thought of writing down that are implicit in the very logic of the regime of law. Mm-hmm. Like, for example, we could string out a few of these things where John Stuart Mill said, we stop using the language of like and dislike. We start using the language of right and wrong to the extent that we think people may be rightly punished for what they're doing. But the corollary is we should punish people only for engaging in wrongdoing. And we're obliged then to use the most compelling canons of evidence in testing matters of guilt and innocence rather than having people run over hot coals or outrun a mob in the street. And we say also that anyone accused of a crime should have access to the witnesses and evidence against him for the sake of being able to rebut them, and in rebutting them, producing a verdict that is substantively accurate in distinguishing between innocence and guilt. Well, I take that string that'll arise from the very logic of morals, as Mill would have it, or the logic of regime of law. And I come up to the conclusion, this notion of your right to see the evidence against you and the witnesses against you for the sake of rebutting them. My logic, what I submit to you is that would be there, even if it weren't in the Sixth Amendment. Mm-hmm. And I would say it would be there even if there were no Constitution.
I was going to get to this later, but let's jump, since this is a good example, let's say the Sixth Amendment or the Fifth Amendment. We understand this. I think we might all agree, or most of us would agree, on the general principle, right? That you ought to, even in the absence of a written amendment on this point, be confronted with the witnesses against you in a criminal trial. But what are the prudential limits on that in a given case, right? What if the witness is a child, a terrified child? What if the witness is deceased? Does that mean
Craig versus Merrill?
What if the witness is deceased and they're not available at all to testify? Does that mean you shouldn't be on trial at all? I mean, how do you temper the basic principle that you've ascertained with prudential limitations?
Well, we should note that let's take that principle I mentioned before. We don't hold people blameworthy for acts they were powerless to effect. We may find all kinds of complicated cases in which we know, was Jones really under the ether? Was he really incapable of making decisions when he was in surgery? Was he really under state of hypnosis? The possibilities may be maddeningly variable. Because we have the principle, it doesn't necessarily give us the guidance through the case. We have to sort these things out. Mm-hmm. But the thing I point out, Adam, is that even though your judgment here will still may be contingent on reading carefully the circumstances of the case. Was Jones really incapable of governing himself. The one thing that will never be contingent, the one thing that will always be there, is the principle itself. That we may not hold people blameworthy for acts they were powerless to effect. Now, what you understand, that it makes a difference if you understand, there, as the founders said, there are axioms that say, axioms, necessary truths, that those principles will be there, be true of necessity. And that doesn't relieve the rest of us of the need for imagination and sorting out the differences in these cases. Well, you mentioned, I guess, Craig versus Maryland, where Sandra O'Connor was pointing out that, yeah, sure, we've taken affidavits in certain cases where people had died with we've done things of that kind. And those are cases of youngsters, right? Taking evidence, sure. And Scalia was quite opposed to that. He thought it was a categorical injunction, but he took the categorical as from the grammatical form, that the witness shall enjoin. Okay, but it's not categorical in the form of the principle. This is one of the few moments, one of her rare moments of lucidity, where she got something right. She said, "You have to say what's behind this provision. It's a principle of being able to confront the evidence. You may be able to confront the evidence here through closed-circuit television. You could see the youngsters and so on, and we could satisfy the principle." Now, my own hunch is that Nino got it right as an empirical matter.
Okay.
That
in the witness case.
In the witness case of allegation of sexual abuse on the part of people running a daycare center, it was like 5 or 6-year-old. My hunch was empirically he got it right, that we'd probably get more reliable evidence by forcing that youngster to be in front of his accuser. But it struck me as curious in light of his own jurisprudence, because the people of Maryland thought this was consistent with the principle. This might be, we could protect some vulnerable witnesses while being sensitive to the main principle. Why not experiment? And if it turns out that Scalia was right most of the time, we're free to change it. Yeah. So I thought they were more consistent with Nino's jurisprudence to say, well, let them try it this way. There may be different ways of achieving the same principle, and there's no reason for us to impose the same uniform judgment across the country.
So there's two ways to think about how this plays out in a given case. One is ascertain the principle and then apply it in a given case and temper it as necessary.
And there's no surcease of the need for practical judgment, right? Understanding what kind of a case you have before you.
Well, Justice Holmes, who I know you're a big fan of, being sarcastic. Justice Holmes famously said, "The merit of the common law is that we decide the case first and the principle afterwards." Right. But I think the best reading of what he's saying there is that you don't know precisely the contours of the principle until it's lived out in real experience and you see the results. You're saying that gets it wrong, that we decide...
No, that's still consistent with what I'm saying. Look, you find people arrested for putting out leaflets in a small town. The leaflets are thrown away, and is this simply a case of municipal cleanliness? Yeah. Or do you find that the leaflets are barred only in the case of certain kinds of leafleters? You may have to find out something more about the case in order to understand what principle truly engages the case.
So the line I pulled out of your book, First Things, you say at the very beginning.
No fair. Citing me against myself.
You don't have time to double check this, so please take my word for it. But you say in First Things, the central problem, of course, involves the ground on which we can claim to know the existence of morals or any truth of moral standing.
Right.
So how do we all, and judges especially, and I'll get back to judges in a little bit, how do we go about reasoning to these principles or identifying these principles?
Well, James Wilson and others, these precepts of that, they involve simply some of the principles of common sense, or what J. Budashevsky said, the things we cannot not know. Yeah. For example, if I ask the man on the street, what do you think, what would you say if Jones were really under surgery at the time the burglary was committed? What if you say if Jones had not been born the time the crime was committed. The ordinary man on the street would say, well, what's the problem? He couldn't possibly have done it. Or if I ask the man on the street, how do you explain why, even in this age of animal liberation, we're not signing labor contracts with our horses or cows, or seeking the informed consent of our household pets before we authorize? The ordinary man would think, what's the problem? But if you understand that, you've got the clue to all men are created equal. The assumption was you don't rule beings who can give and understand reasons in the way human beings are compelled to rule dogs and horses. Now, those deep principles, are you the same person you were yesterday? Jones says, I'm not the same man you caught embezzling. Since that time, I've undergone a shift, and if you punish me now, you're punishing quite a different person. Sorry, Jones, the principle of identity comes in. Yeah. You are today the same person you were last week. You may have to sort it out, but no, we're clear on this. There's certain things that those deep principles, as Jay would say, they're part of the common sense, as Thomas Reed and James Madison. So at the deep level, this is what Jefferson had in mind. He said, you can give a serious moral question to a plowman and a professor. The plowman is as apt to give you the right answer as the professor, because he's not being distracted by artificial rules or theories. So at a certain level, I'd say, those deep axioms have to be things that are accessible to ordinary folk. Now, but I assume that the learning we encounter here as we engage in these deliberations will give us some practice.
Now, those are pretty clear examples. What if you stop the man on the street and ask, do you believe there's a natural right to engage in sodomy? You might get a funny look when you ask the question, but once you explain, no, this is about a Supreme Court case.
What is sodomy?
Yes, the Supreme Court case, Lawrence v. Texas, right? You have a court very sharply divided, and an American public very sharply divided on the case of Lawrence v. Texas and gay rights. If natural law reflects principles upon which we can largely agree as a matter of common sense, then what about the hard cases where we're asking very fundamental questions on which the American public doesn't arrive upon a consistent answer with common sense?
Well, I think the main principles are, this is nothing new. After all, at the end of the 19th century, after the Civil War amendments, and the people say, why don't you put black people on juries? Jesus, never thought of doing that. Don't put dogs on juries. Don't put these people on juries. Sometimes it just doesn't break through. We wouldn't have think of. At a certain point, what's the question so old we can't remember the answer. It doesn't mean we have to deliberate anew about this. So you could either respond to the case of marriage by simply taking the easy conservative cop-out, not part of the tradition. That's something conservatives invoke when they don't want to face the question of the moral justification for the practice they're trying to defend. And Scalia saw it as a way of evading the vexing moral question. Or you could do it that way, but the other side doesn't accept it that way. They say, well, tradition, slavery was part of the tradition until it was overthrown. You have to do, as Holmes would say, you have to say more for any statute than to say it's been around here since the time of Henry IV.
Right.
So you put the question to people, okay, fine, apart from the tradition, what makes it defensible now? And at a certain point, I think the conservatives would be obliged to say something more about what makes the notion of marriage, the union of a man and a woman, confirmed up as a commitment in law, what makes that the most defensible form of what we call marriage? Now, most of the conservative lawyers didn't do that, and some of the conservatives I know didn't want that argument to be made. They simply want to say it's not part of the tradition, it doesn't fall to us. The Constitution says nothing about, this is the line, the Constitution says nothing about marriage. Therefore, we are not in a position to proclaim any rights arising from marriage coming from the logic of this Constitution. But the Constitution said nothing about marriage either in 1967 when they struck down the laws in Virginia that barred marriage across racial lines. Didn't say anything about that then. And what they had to do then was explain why discriminations based on race were really irrelevant to the capacity of people to enter into the commitments of marriage. In the same way, I think that the conservative position would have been to rise to the challenge. The other side makes a moral challenge. And you don't get off it by saying, well, actually, Scalia said, I don't care what theory of marriage you install, as long as it's done in a democratic way. I think the conservative side had to say something more substantive than that. But I'm afraid I may be drifting off and losing your question. What I'm saying is, yes, you can have these principles. They certainly don't. Just the principles may be in place, and suddenly people are thrown off because they're being asked to explain and defend things that they thought never needed explaining. Why don't you kill that child in the womb? Why am I not free to do that? A friend of mine in Denver reported somebody arriving at the office for licensing seeking a marriage license for himself and his horse. And he said to me, you would never guess the reason they gave for denying the application. I'm happy to tell you I did guess it. That the horse wasn't yet 18.
Oh, oh, so he's being...
No. But I offer this example. You just never think we don't remember the reasons we would say no, because no, it was so deep that no one ever thought. And now at that moment, you're put on your mettle. Yeah. You have to say, okay, we've just floated for years with what we thought were settled understandings, but now it's a great challenge for us. Yeah. And after all, look, even Scalia wasn't certain as to whether this understanding of marriage, so long settled, was something he was prepared to defend on moral grounds. So it's not. I don't claim it's easy.
See, I tend to focus on the administrative state, and so I thought the answer was going to be the bureaucrats didn't have a box marked horse to check on the form. But no, the point you just made, it's a quote I pulled from this book, which I hope you take a copy of, Constitutional Illusions and Anchoring Truths.
Well, as Sam Goldwyn said, I don't care if I make a nickel on this movie as long as every man, woman, and child in the country sees it. Right. No, thanks for giving the book a plug.
No, of course. Well, you say the point that you're making now, which I think you make beautifully in the book, is the Constitution with settled understandings and supposedly settled principles may keep generating for us unsettling surprises.
Oh, yes.
But that is in part the charm and the deep magic of real principles. Right. So how best do we ascertain that the surprises reflect the ramifications of a principle we just didn't understand, and how do we know when the surprise is actually reflecting upon a misunderstanding of the principle in the first place? Let me put it more pointedly. When we're surprised, how do we go back and re-question whether our conception of the principle was accurate in the first place? For me, I'm attracted to a Constitution that puts more emphasis on tradition than is currently given by the Supreme Court. There's an interesting project by some law professors up at St. John's Law School called the Tradition Project, which sounds like a real party. But one of the reasons why I'm attracted so much to the work of Alex Bickel and others and the early works of Jaffa is that they're looking for evidence of principles. They're inferring principles from felt, lived experience in the society we have today. And I hope I'm not misunderstanding your approach in that I think you take it from you look through the other end of the telescope, or you point out that they're looking through the wrong end of the telescope, that we begin with principles and then work our way through experience, not vice versa.
Well, I think of that line in Kant in the Critique of Pure Reason that, of course, how else should the faculty of knowledge be called into play if not in the presence of some experience, right, that presents the question? But the fact that we have the experience already, there are things that must be in place for us to have this experience. You know, why do we assume that the action is being played out in the sequence we're perceiving? Why do we understand? We could understand the logic of a happening, that one event precedes event B follows upon A as though by rule. That experience of a happening appears in a sequence. My experiencing of this room can happen in any sequence. I can see the ceiling before the floor, but those certain things of that kind. Yes, forgive me, a priori things, time, space, the sequence, cause and effect, imputing to people the active power to cause their own acts. These things are there, without them you couldn't even have the experience. So I think the two are molded. It's a great question, Adam. And the interesting, for example, we learned something. I think arguably we learned something about the logic of the separation of powers that people don't quite appreciate. They talk about the concentration of power, but there's a marvelous passage in Locke where he said the logic of this is that when you legislate, what you legislate is being put in diverse other hands to be administered, which is a near and dear tie upon you to make sure you legislate for the public good. Put another way, what you've got to understand when you legislate is that you will not be allowed to manage the prosecutions that come under that authority is going to be put in hands other than your own. It could be the hands of people unfriendly to you. So you better be careful that you don't legislate what you would not be willing to see applied against you with full force, which say, people understand that the separation of powers actually renders operational the categorical imperative. You see, this may come as, it's been there for years, and people can talk about it and not recognize that implication is lurking within it. We have the principle on ex post facto laws, and yet we find we do lots of other things with retrospective judgments. A lot of the tort law is affected by retrospective judgments. We had the first guy hit with a judgment on herpes. There's nothing in the statutes about your vulnerability, your liability for giving people. But apparently we must mean here that if you're aware of the condition, you know how it's transmitted. What plausible reason did you have for not warning your partner? Well, there's no statutes on this. Right. You know, this suddenly springs up, or Congress legislates this banning from the country people who are involved in war crimes in Europe between 1933 and 45. And one of the first persons caught in this was Kurt Waldheim, the former Secretary General of the United Nations. You could see that in the old positivist style, he could say, oh, if I'd only known that if I could be barred from the best restaurants in New York, I would have behaved myself in the Balkans, in the... but then we realize we are doing this all the time. We do this with things like wage price controls, or I remember once giving my students a case where Congress was changing the laws governing, removing the liability of divorced husbands to pay child support. And within 7 years, they legislated 3 times and made each one retroactive. And there are these people just caught in the winds of this legislation. And in other words, we've done this. It turns out that there are things we can do ex post facto. We've tried to mark off criminal laws, though the founders were not clear that it should be confined to criminal law. Okay, but I'm saying we discovered it may not be that all retrospective acts are ex post facto. We thought those things we call ex post factos are those retrospective acts that we think are not justified. But when suddenly Congress reimposes price controls on oil, and the judge says, well, and make it retroactive, on those contracts on this, and the judge says, well, it was done for the public good, so it must be justified, even though it's ex post facto. So we're saying the formula, we still have to pierce beneath the surface of the formula. And what is it? If our dentist, I'd be offering up root canal. What am I? You're asking me, so I'm telling you, it's all going to end up with people deliberating in a serious way as to whether this bit of retrospective legislation was finally justified or unjustified. We throw them back on those deep principles, which, of course, are not set down in the text.
Now, as you mentioned,
I hope I'm not just going around your question.
No, not at all, not at all. But so we do have 3 branches of government.
Right.
By and large, Congress legislates and makes law going forward. the executive branch administers these laws that have been passed more or less going forward. Why? Judges, though, as you said, that their task is by and large to make law and apply it to things that have already happened in addition to things going forward. Why not limit the province of that narrowly with a written constitution, binding the judges to enforce just the plain text of the words as it exists, and then leave the rest to be handled by the states or by Congress? Because this brings me to your upcoming First Things article, the magazine, not the book. But I got a preview of the article, and I recommend it to everybody when it comes out, because it is very much a challenge, as you've posed so often, to your fellow conservatives, including your friends like the late Justice Scalia, to reevaluate their view of written constitution. And you say we're at a turning point, perhaps, a turning point when conservatives should and will come to a deeper understanding of the limits of written text. Do you want to talk about that, about your article and your debate with conservatives?
Oh, I guess I never left it, but
Yeah.
no, I'm just trying to see where to hook into your original question. And I've had one, and I was pointing out that even my friend Scalia would make his way to things that are outside the text.
Right.
He was doing this all the time. And in that one of his last cases, one on Williams Yulee versus Florida about the freedom of judges freedom of speech for judges in re-elections, and Nino said, it is an axiom of the First Amendment that you may not make judgments on the content of speech. Well, I don't see it is an axiom. I've been arguing for years that we may make, but that axiom is not in my copy of the First Amendment,
Right.
and it's not in the text. During this litigation over this litigation over the banning of Trump's immigration order, a couple of these judges were getting the whiff of it could be some aversion to Muslims, discrimination behind all this. Well, where in the text would you find a ground for that kind of a judgment? It's not a religious test imposed by law, not under Article 6. It's not a matter of free exercise. What seems to be taking hold here is that people should not suffer penalties based upon their religious commitment, the kind of disability based on religion. We had young James Zobrist, for example. You may remember the case, the youngster who had deaf in Arizona. He had access to an interpreter under the laws of Arizona and the United States. By the judgment of some county attorney, he lost his claim to the interpreter as soon as he moved into a Catholic school. Now, those privileges flow to him under the laws of the United States. You see, he loses them because he moves into a Catholic school. But again, it's not in the text. You'd say aren't you not imposing a distinct religious disability? Didn't he know, in that case of young Josh Davey, who
This was on
Davey versus Locke, was it?
That's right. The state had a program for scholarships for college study. Josh was going to study theology, and the state said,
Become a minister.
Right.
You could study theology, but if you become a minister, the state will not support that.
Right.
Well, Bill Rehnquist, along with I took the line that this is a matter of federalism. The states could give all kinds of support to religion, and the state could decide to give no support to religion. So this, on the basis of federalism, Bill was willing to sustain it. But Nino was in opposition. And the opposition, no. But the only ground for denying it to Josh Davey was that he was going to enter the ministry. It is clearly a religious disability. Okay, now here's something. It's not in the text, and yet it seems to be taking hold. Now, there are many other places where, we heard for years the right of Congress to alter the appellate jurisdiction of the courts, right? And we're going to do that for abortion, right. Just as we've done in the Norris-LaGuardia Act to restrict the powers of the courts to issue injunctions to break strikes. We've done it in the past. The precedents were all liberal. And we're having people tell us, even though it's in the text, you may not use it. It's been repealed by the drift of time. But take one other thing. Here's Neil Gorsuch at the hearings last week. And Blumenthal's asking him, what about Brown versus Board?
Yeah.
Okay. And Neil says, and Gorsuch said, oh, that's very clear. It's part of the original understanding of the Equal Protection Clause of the Constitution. And so is Loving versus Virginia.
Right.
Okay, we say, my God, it's certainly not part of the original understanding. The point has been made quite often. John Newman made it, I think, that the same Congress that passed the 14th Amendment had plenary control over the schools in the District of Columbia. They never thought that anything contained in those principles enjoined them to desegregate the schools in the District of Columbia. It was hard to believe they thought anything in what they've just enacted would enjoin the desegregation of the schools in Topeka. And we know also that Lyman Trumbull assured his colleagues up and down when he was managing the bill, nothing in that 14th Amendment was going to challenge those laws in Illinois as well as Virginia that barred marriage across racial lines. And you knew that if he couldn't give that assurance, that 14th Amendment had no ghost of a chance of passing. Okay, so here's Neil, and he says, it's part of the original understanding. It is certainly not part of the original understanding. So what I take you to mean is that somehow you see a principle that you think should have been recognized as part of the logic of that Equal Protection Clause. It's not in the text. It's never been in the text. It is not part of the precedents. It is not part of the original understanding.
Yeah.
What gives you your confidence now that this gives you an accurate rendering of the Constitution? If not, that you are making a principled case.
Well, it's a line that I liked from the article. You say Scalia.
This is my current one?
I keep quoting your own words.
Thank you.
But this is from the upcoming First Things article.
Thank you.
You say Scalia persistently offered us handsome examples of the reasoning of natural law while claiming that it cannot be done. And I guess my question would be.
That's right.
Because you say in the article, as you just said a moment ago, that Scalia would persistently appeal to principles beyond the mere text of the Constitution to illustrate his points or to justify his points. Well,
right.
What about this? What if originalism, as Scalia and I think Gorsuch and others practice it, what if it is effectively the furthest and most effective way it's the furthest way that let me put it this way. It's the means by which we can most fully vindicate the natural law principles that you are urging judges and the public to embrace, to recognize. What if originalism is the best vehicle for bringing this as far as it can be taken in the political environment that exists today? What if originalism is, in the end, the most prudential way of bringing natural law into full effect? Should Scalia be criticized, or should he be celebrated for, as you say, he offers handsome examples of the reasoning of natural law while claiming that it cannot be done so. It cannot be done. What if the best thing we could do is offer these examples while claiming that it's not actually what we're doing?
Well, this is.
So that was very rambling. I'm sorry.
No, yeah. Now I know some of our friends say we can invoke the natural law when we have some historical evidence that the American founders understood this provision of the Constitution in natural law terms. That's very interesting. Yeah. But that very rule you're offering, we may invoke the natural law when there's historical evidence that the founders saw it. That rule is not in the Constitution. Yeah. How do you claim to know it? It's like the line that Hamilton raised in Federal 78. We work under this rule of construction, that any later statute supersedes an earlier one. But that's not the rule we work with the Constitution, because the Constitution coming earlier must be able to override the statute coming later, or else it loses its function as a control of the legislative power. Then Hamilton says, well, how do we know this? It's not part of the positive law of the Constitution. It's the reason and nature of the thing. When you start, our friends, looking for a way out, find themselves backing into these propositions that have not been set down, and they think they're part of the reason what you're backing into, as Hamilton said, what was those reasons which antecedent to all reflection and combination. You've just backed into an axiom or first principle. You've never left the natural law.
Hamilton also says, though, in 78, that the judges should, I think, you correct me when I'm wrong, that the judges should be bound down by a system of strict precedents and rules.
Absolutely.
So what's more important, binding the judges with rules and precedents, or making sure that they give vindication to these antecedent principles?
As my favorite epistemologist, Lou Costello, used to say. That's an excellent thought. I was just going to think of it myself. You took the words right out of my mouth.
Maybe you're already thinking it, you just didn't know it. It's a pleasant surprise.
No, look, a couple of things. Of course, we begin with the text because it was set down there for, first we have the structure. It was set down for a reason. It's set down by minds that are better than ours. I remember once giving my students in the course of the founding Hamilton on juries in civil cases. And I said, I guess it may be conceivable that this explanation could have been given with more clarity, with more economy, and with more elegance. I just can't imagine how. Yeah. Well, of course you look to those writings to explain what you have before us, okay? And we say we should have some pretty damn good reasons before we decide to change on those things. Now, but going back to your deeper question, this Constitution was formed. Remember, Lincoln in the first inaugural address explained to us how the rule of a majority under restraint, a majority that understands it may not free to decide everything, is the only operational form of government by the consent of the people, government by consent. But it all depends on that deep underlying principle, all men are created equal, meaning we don't rule human beings the way we are compelled to rule dogs and horses. Nino regarded that as simply a sentiment. Lincoln regarded it as an absolute truth. But that was the principle that lay behind this. If that's not the principle, then you're stuck. Nino was stuck with this position. If there's no principled ground for the rule of majority, then you're faced with Holmes's line. The majority rules because it has the power to overbear the minority. That's simply the rule of the strong. Okay, now, let's say we start with the understanding that this Constitution and the laws were put in place according to a natural law principles that enjoin, governed by the consent of the governed. The laws made by these people may be wrong. But as Lincoln explained that, when you have a government founded on this basis, the laws should be changed in a legal way with the consent of the governed. You don't report, of course, if you understand that mistakes may be made, even wrongful things may be done that run counter to here's Senator Pettit of Indiana. Says thinks the self-evident truth of the Declaration was a self-evident lie. I mean, this is a man of high standing in a republic who has utter contempt for the deep principle in which his authority rests. And this is what you're facing. Okay, let's say you have something like that, but the understanding is if you understand there is a ground for this, a natural law ground for the whole regime, that of course you have to treat with respect even the bad laws that may be made there until they could change in a lawful way.
You know, I liked Harvey Mansfield's formulation, maybe it's a self-evident half-truth.
Well, maybe they have. Sure. Look, well, actually, there's in fact. Oh, I'm sorry, Adam.
I was going to say we have microphones here for questions, and so please take questions.
Let me throw one thing in. I remember having dinner at Fordham with the dean of the law school many years ago, not about a dozen years ago. I was going to talk on natural rights and right to choose, and he said, you know, there wasn't much talk about natural law during by those jurists in the first years. And I remember Dan Robinson said, yeah, there wasn't much talk among them about the alphabet either. It was just woven into everything they did. And it finally struck me that could be dealing here with an instance of what the philosophers call a category mistake. To adapt Gilbert Ryle's example. Somebody comes to Amherst. I take him around. I show him the administration building, the beautiful building where I used to teach, social center, the fields, take it back to the house for a drink. He said, oh, that was very nice, but I thought you were going to show me the college. I thought that's what I was doing. So now I can imagine the conversation with the dean. The dean's saying, look, all you've shown me is how a bunch of very literate lawyers kept making their way back to certain axioms that would be the source of rights that would be there even if there were no Constitution. When are you going to show me how they did natural law? Okay. And I think that's where we are.
Well, just one last question before we turn it over, turn the microphones over. I wanted to talk about the Born Alive Abortion Survivors Protection Act.
Oh,
This
right.
has been a major project of yours.
For a long time.
Why don't you tell us what it's about?
Well, this was something. Actually, it comes from a draft I wrote for the first George Bush. That should have been placed when the court did the Webster case in 1989. I had a draft which I'd have President Bush say that now the courts may be returning the issue of abortion to the political arena, but this has been governed by the courts for so long, we may need a conversation before we can legislate again. The other side says that abortion is not infanticide, which means that we need to protect the child at some point. Why don't we invite them to tell us when? And if nothing else is forthcoming, how about birth? The child is born and out, detached from no longer encumbering the interests of the mother. Could we protect that child who's born alive? We had one federal judge, Kevin Hainsworth, in 1977 case, so we couldn't do that. That child born alive is not a child protected by state law. It is simply a fetus marked for termination, which is to say the right to abortion is the right to a dead baby.
So that was Justice that was Senator Stephen Douglas who said this, or?
No,
I was joking.
No,
Sorry.
yeah, it might. No, I'm not sure. No, I don't think Douglas would have said that. So we said, why don't we begin there? Can we just let's invite the other side to join a conversation in which we protect the child who's born alive? Yeah. Well, some of our friends thought it was too moderate. Then they found the bill on partial birth abortion. Yeah. They did that. Then Dick Posner was twitting us in the Seventh Circuit in Wisconsin. He said, "You people never made the claim to protect the child herself. So why does the state have any compelling interest in shifting the killing of the child from the birth canal back to the uterus?" We might have had a point. They'd had to be filled in. So I said, what we ought to do is take that direction of Andrew Jackson's famous line from the Battle of New Orleans, where he supposedly said, "Boys, I want you to elevate them guns a little lower. Let's take it back to claim to protect the child herself." All right? And to say, so when the bill on partial birth abortion was struck down in Stenberg versus Carhart I was there in the courtroom, and Nino he was concerned about Hill versus Colorado, gave over to Clarence the task of reading the dissent. So it was June 24th or something like that, 2000. After that, the Right to Life people came back to me. This is the time to go with your bill. And we went with it, but they thought that we'd strip the penalties from the bill for the sake of making it a pure teaching bill, to plant premises in the law, to plant the premise that even that child marked for abortion may have a claim to the protection of law. We wanted to put in a preamble saying, she must have a claim to the protection of law that cannot pivot on the question of whether anyone wants her. I said, we're open to amendment. Is that the reason you're protecting the child? Or are you saying you protect the child as long as it pleases you to protect the child, but if it no longer pleased you, you wouldn't protect the child? Well, if that's what you mean, tell us. Well, as we started with our preamble, a bunch of so-called moderate Republicans threatened to join the Democrats in closing the Congress at the height of the presidential election in 2000 if we went to the floor with those inflammatory findings. Oh, God. And Henry Hyde gave in because we had certain pro-life congressmen like that, the guy in L.A., he said, for the sake of preserving a pro-life Congress, you need to have some pro-choice Republicans. And we'll be sensitive to that. Oh, what we discovered, though, in the meantime, the years, is that there was far more of this killing going on than even we ever anticipated. Jill Stanek, this nurse in the Christ Hospital in Oaklawn, Illinois, who blew the whistle on the live birth abortion, deliver the child live and put the child in the refuse room to die. The safest abortion of all, of course. No introduction of instruments into the body of the mother, no danger of infection, and so on. Well, she got on the radio, and nurses were calling from different parts of the country saying, "Are you kidding? We've been doing that in our hospital for years."
Wow.
And then we had the killings in Philadelphia with Kermit Gosnell. Mm-hmm. You know, it's better to go back to this. And I formed a working committee in Garrett, when did we do that? 2015, wasn't it?
Late 2014.
Yeah, okay. We formed a committee, and Trent Franks picked up on this. He invited us to work on furnish some language for it, and to add the penalties, finally to restore the penalties that had been struck from the original bill. Well, they're a mild version of what we still could have done. But we thought it was going to take all of Congressman Nathan Arts to keep his Democratic colleagues from voting against the bill. But Obama ran true to form. He threatened to veto this bill. He killed a comparable bill in Illinois when he was in the legislature there. And that liberated the Democrats to vote their true sentiments. Can you believe this? Goes to the floor in September 2015. The vote is 248 to 177. Virtually every Democrat in the House votes against the bill to protect the child born alive. Now, so in other words, it was Obama's position was that all of the rights mentioned in Roe versus Wade would be threatened with unraveling if we could protect the child born alive. We're making the press to raise this question during the confirmation hearings. They say, is this still an open question? Whether Roe versus Wade entails the right to kill? If it is, then guess what? The meaning of this case is still not settled. 43. It is not, cannot be the super duper precedent you claim it is. The meaning is still not settled. But this should have been the position that, this should have been Hillary owned this position. This is the position that the Democrats should have been made to defend, that from their understanding now, the right to abortion is not confined to the pregnancy. It entails nothing less than the right to destroy the child who survives born alive. I don't understand why the Trump campaign never picked up on that. I don't understand why the media picked up. I don't understand why Catholics in the media did not pick up on that, why the question was never raised. And it's one of those vices of our current politics. There are certain subjects people don't want to talk about. Lincoln said, we can't talk about slavery. We can't talk about it in the churches. It's too divisive. We can't talk about it. It's the question that runs to the core, and we can't find a place to talk about. What Lincoln showed us is that the real task of a statesman, first, is to get clear on the issues that really do run to the core, and then teach the public in a gentle way how we can talk about these things. And the fact that he succeeded is shown by the letters of those Civil War soldiers where Lincoln's lines were running through those letters. Say, in giving freedom to the slave, we are securing freedom to the free. Noble and like in what we're giving and what we're preserving. It worked. It could be done. And so the task of leadership is actually giving arguments and speaking, not putting out tweets.
Right. Well, we still have some time. If anybody has questions, there's one right here, Anya, in the second row.
I'm sorry. Thank you, Heather. If I filibustered, okay.
So as the natural law that you're talking about here, it relies upon kind of a reason and logic. And so in my mind, that suggests to me that it's not up to popular vote. It doesn't really matter what the public necessarily feels. It's what about logic and reason derive the conclusion from. So the public may be entirely wrong if the reason and logic is correct. And if that's the case, how do you prevent judges from instituting their own bias or introducing bias into a situation where they say the public is entirely wrong, but this is the fundamental principle that must be applied here?
And let me add, I mean, like Rumsfeld said, you go to war with the army you have, and this country decides cases with the judges it has, the judges it's always had and probably will always have. What does that mean for the practical application of natural law?
Well, remember somebody at a lecture at Georgetown said, Professor, is there any alternative to reason? And I said, did you want to dance? You have something, the only corrective to that, what is the corrective? Stop using moral reasoning, or to say, you think he has it wrong, you have counter-argument to show why it is wrong, why it is specious. My complaint about it just came out in this article. We found, one of the most important pieces for me in abortion was this wonderful essay done by Paul Ramsey years ago on the development of the child week by week, month by month. And we went back to Roe versus Wade and found that the lawyers for Texas did an even richer version of that brief with more up-to-date material. It was a compelling brief. And yet, nothing of the substance of that brief made its way into dissents written by Rehnquist and Byron White. They simply went back, well, it's not in the text of the Constitution, therefore this is simply raw judicial power. What a difference it might have made for the denouement, which the story I tell here, I hope I can get away with. It was about 3 weeks later, there was a dinner party in Washington with Jim Buckley and Potter Stewart, who was classmates, I guess, from Yale. And Jim was saying, how did you come up with something like this? And then Jim started going through the development of the child week by week, month by month. And Potter Stewart said, where did you get that? Jim said, are you kidding? It's in all the textbooks and everything. It was in the brief, for God's sakes. Did you read the brief? Now let's say that White and Rehnquist, instead of using a mechanistic, well, it's on the text, actually had given. This is what I think is the most natural thing. You could either take the exercise of power, something that justifies itself, or say, with the exercise of power, we're removing the freedom of people. We have the burden of just showing the justification, what makes it rightful to impose those laws. And what a difference it would have made if the dissenters would have put down the compelling evidence and reasoning that would have justified, and that would have been on the record. And even if it could have turned Stewart that day. It might have turned somebody else. They might have held back from reaching that decision with such a closely divided court. But even if it hadn't, my pitch is it would have made for a far more coherent jurisprudence. We would have had on the record exactly what the issue was. And if we think Blackmun's history and his reasoning was defective, the answer to that is saying, well, it's not in the Constitution, was to show what was wrong, deeply wrong and mistaken in his reasoning. I think that's the only way we could do it. This is Michael Maybach.
Yes, thank you very much, Hadley. So we're going through almost the end now of the Gorsuch nomination before the U.S. Senate. And in the best case, one would think a U.S. Senate hearing with a Supreme Court nominee would be an educational experience, a civic educational experience.
No, not anymore. Not anymore.
And that's what I wanted to ask you about. Why?
No, it's hopeless now. It's obviously hopeless. You know, what Neil say? He was asked about Obergefell, and he said, that is now settled law. Whoa, really? Tell me, by what criteria conservatives have been arguing for years, could that possibly be considered settled law? It was a closely divided court, 5-4, impassioned dissents, running against an understanding of marriage in place universally for a couple thousand years. What possibly makes that judgment settled law? What I think Neil was saying is, I'm not going to say anything critical of that case today. That's all I think he was saying. And it's obvious that you can't have a serious conversation about these things in this setting. Anything you say that could possibly have a whiff of criticality and any liberal judgment would be taken as the pretext to vote against this guy.
So what I wanted to ask was, has it always been so, or was there a moment?
No. Well, of course, I wrote a book about George Sutherland, the great George Sutherland. Mm-hmm. He was coming back from negotiating for the country on patents or something. And he heard that Mrs. Harding was sick. He sent a note to Mrs. Harding to the president saying, I'm sorry, I've heard she's sick. I hope she's well. And he gets back to his apartment. He gets a note from Harding, says, thank you very much for your note. Oh, by the way, a vacancy occurred on the court while you were away. I put your name up and you were confirmed. Yeah. But I remember years ago, there was a line where Frankfurter was up and he was being grilled by McCarran. He said, what about this book by Harold Lasky on Marxism? Do you accept the thesis? It's a complicated book, Senator. Do you accept the thesis? And then Frankfurter said, Senator, have you read it? But there was a time, I remember when I was out, right after 9/11, I was up in Utah with Mike McConnell, who said, he was up for that judgeship, and he said, the handlers were telling me, don't argue with these people. And he said, I can argue with them. I can hold it. I've been doing this all my life. Why are you telling me not to argue with them? I think, look, it wasn't going to make a difference for the vote. You're not going to get many Democratic votes anyway, but the real problem was you might lose a few Republicans, wouldn't you? Which tells you that there's an asymmetry here. The other side, the Democrats will make dedication to Roe versus Wade an absolute test, and our guys have to dance around it, pretend they haven't read it or haven't some judgment about it. They're open to it. That shows the critic. It may show that they've won the culture, so to speak, or we concede this to them, that we will dare not speak in public on these questions. And I think that betrays a want of confidence. And look, I had this scheme. I'm sorry, I should not filibuster. Maybe another question over here. But
sure.
I had this scheme for getting through these hearings and on abortion, and a very interesting thing. And our friends, keeping political experience even, our friends divided. Some say, "God, that's brilliant. Why haven't we done it?" And others say, out of your effing mind." And it went like this. If you had a woman, especially with a gal like Marion Glendon, you say, "You know, Senator, about Roe versus Wade, I find a lot of lawyers are confused about this." Marion Glendon took a survey among 25 of her colleagues at Harvard years ago about Roe versus Wade. Only 5 of the 25 could give a faintly accurate account of what was in it. And so, you know, Senator, I find even lawyers are confused. Could you tell me how you understand that case? And if he says you can have an abortion in the first trimester, you correct him. You can have the abortion through the entire length of pregnancy, and even when the child comes out. We found, okay. There have never been more than like 24% of the public in favor of abortion under any circumstance at all times. You're not going to rally the country to support this thing. And then our person says, step 2, well, you know, Senator, I can't pronounce today on the kind of restrictions that would be justified or unjustified without virtually inviting the legislation and the litigation I'd be asked to judge. End of conversation. Now and forever. I tried this out on a friend of mine who's on the D.C. circuit one night at dinner, John Roberts. And John says, "Oh, there you go, back into the assumption that Biden and company care about the reasons." They don't care about the reasons. I said, "So John, your formula is just put your head down and take the pummeling. Is that it?" "Yeah, that's all." Well, I'm afraid that's what we have now. And I think it betrays a want of confidence. And the assumption is, if we just do this, we'll get through this. Then I guess I'd ask the Herman Cain question. How's that been working for us?
So that was John Roberts when he was on the D.C. circuit?
Yeah,
Wow.
yeah.
Right over here.
Thanks for a wonderful
This is Frank.
presentation.
Thanks,
Yes.
Frank. Frank, take it.
Even though your analysis has not relied on the existence of the Ninth Amendment, I do have a question about that in light of the Privileges or Immunities Clause of the 14th Amendment, and that is, assume no slaughterhouse cases, which of course eviscerated that clause substantially, the Privileges or Immunities Clause. Is there anything that the Privileges or Immunities Clause would have embraced in terms of rights protected under natural law that would not have been otherwise included in the Ninth Amendment? Or to put it another way, would the Ninth Amendment have been even necessary? Is it necessary even to talk about it in light of the later 14th Amendment Privileges or Immunities Clause as properly understood?
That is quite a question, and if I answer that, Frank, eyes are going to glaze over in this audience. But there's a chapter in my book, Beyond the Constitution. I have a chapter called Life Beyond the Clauses. So I find some of these cases where letting indigents into California, where everyone agrees about the outcome, and they're tearing each other apart over the question whether it's the Equal Protection Clause, or the Due Process Clause, or privileges and immunities. And what they don't see is that all of the judges were making the same underlying moral argument. Their arguments began at the same place, pivoted to the same place, and find it the terminus in the same place. The underlying moral structure was the same. What I tried to show is I could take that underlying structure of the moral argument, and I could simply translate it to due process, equal protection, anything else. And this is part of my argument with this. I think one advantage of, it's an interesting question, one advantage of privilege and immunities, I suppose, if you take, was it Bushrod Washington, and, saying, either you can understand that it's just whatever, you have a claim to whatever local people have. Okay, in which case, black people coming in from Harlem, going in the South, would have to sit in segregated buses and so on. Or you could mean they're the rights that arise out of the very logic of a Republican government. He says it would be too tedious to enumerate them. Right? I go with that. If that's what it means, they would say we are open to all those those principles that arise out of the very logic of a regime of law. We couldn't, as the founders said, we can't settle them all. In fact, that's not our business. We're trying to create a structure of governance, and we assume we are banning only unreasonable searches and seizures. At every point, you're thrown back on these principles of judgment that are not themselves listed in the text. And we keep pointing outside the text those principles of judgment. We understand we're going to have to function that way. There may be a couple of other vehicles that will get you there. And I'm sure that when I leave here, I'll have the wit of the stairs and think of what I should have told you at this point as a capping argument. But I think that's the one place where I think privileged immunities could be. But we understand that the point is there could be a vehicle there that allows the judges to reach. But look, they're doing it anyway. Marshall in McCulloch versus Maryland said, the Constitution gives the Congress the power to punish only piracies. Whoa. But I assume that if Congress can create mails, it should be able to protect the mails from theft. So he draws the implication from the very logic of establishing a government. A government must have marked by the capacity to legislate, to set down laws and therefore to enforce them. So look at this, the way they did it in the past, they could do it in other ways and found other paths for making their way back to those anchoring principles. But I think finally it's those principles that underlay their judgment.
Well, okay, one last question then, picking up on that. I've always wondered why you called the book Beyond the Constitution. Why not underneath the Constitution, but seriously, or within the Constitution? Why beyond the Constitution?
I hadn't thought of that before. I would say I belong to the Constitution. I think because again, I simply thought we're pointing to something outside the Constitution that was there before the principles were there. The founders drew upon those principles in order to shape the Constitution. Yeah. Those principles didn't start with the Constitution. Yeah. And as Lincoln and Sutherland reminded us, the Union is older than the Constitution. It's been there longer. The Constitution was made for a more perfect Union. Okay. Yeah. But I thought we're constantly drawn outside the text to the principles that were there. We have, I'm blocked for this by the I'm blocked by the fire department from walking down my street because they're fighting a fire. My liberty to move has been impeded. Yeah. I don't think my constitutional rights have been invaded. That liberty was restricted with justification. When they did the First Amendment, Benson said, well, it doesn't mean you have the right to assemble for any reason. It has to be assembled in a lawful way for legitimate ends. Yeah. They understood that that the judges will always pivot on your understanding of what is justified and unjustified. And they didn't think it would be tedious to start listing all those grounds. And there are surely things that we haven't taken, that we all understand, but haven't thought to sort of set down. So I thought it was...
Well, I feel very justified in having you here today. I'm very thankful for you to make time for us. And
let me tell you, this is the only second time I've done one of these things.
Okay.
An interview before a crowd of audience, even of friends. Can I tell my favorite story about second times?
Sure. We start with first things, we end with second things.
Yeah, it was second thing. It was a story about one of those courses on sex in the family that used to be given at schools like this. There's a story of a guy who did these courses. He's asked to give a talk to the local Kiwanis about modern sexual practice. Something came up, he couldn't go. So he tried to get a friend of his in English to do it. He said, what do you mean I'd be embarrassed to do it? It's okay. Any literate person can do it. I'll give you my notes. I agreed to go to talk to the Kiwanis. His wife sees him leaving the house at midday. Where are you going? To go to the Kiwanis. What are you doing at the Kiwanis? Lecturing on what? Well, I don't know what they said. Parachute jumping. He just taken it up. So about a week later, his wife in the supermarket runs into the president of the Kiwanis who says, your husband gave the best damn talk we've heard all year. I said, really? That's surprising. You know, he's done it only twice in his life. And the first time he got sick to his stomach, and the second time his hat fell off. So, Adam, this is only the second
On
time
that note.
I've done this. Thank you for inviting me.
Thank you, Hadley. Thank you, everybody, for coming today.